get to that potential problem, if I know you may not think it's a problem, but there are clearly many people who do. And that's because of my questions about whether or not this is the right plaintiff, given the amount of competition for mobile games and where Apple is relative to Epic, or I think it's Tencent who owns a huge share of Epic. But where is, in your view, where is the competition? Where does that 30% number come from? Why, as I asked before, why isn't it 10 or 15 or 20 or 30? There doesn't seem to be competition, and that's what we're concerned about. Is competition, not Epic, not any particular developer. Competition.
Your Honor, two responses. First of all, to your specific question, the test for monopoly power is whether the alleged monopolist can increase prices by decreasing output. And as for monopoly maintenance claims, there needs to be some indication of anti-competitive conduct that is used to maintain and sustain a monopoly. Here, Apple established a business model back in 2008 when it first launched the App Store with 500 apps. Since that time, and in 2011, when it began in-app payments for in-app purchases, it set its commission at 30%. Neither of those things have changed since 2008, except the output has exploded. It has gone from 500 apps in 2008 to 1.8 million today. The commission has never been raised. In fact, it has actually decreased on subscriptions after 1 year, and that is something that doesn't involve Epic, Your Honor, but it does involve other participants in the App Store. That has been decreased to 15%. As Your Honor has already noted, 84% of apps are absolutely free, and Apple recognizes nothing from those. And as to the effective commission, if you will, people were willing to pay, and Apple marketed when it obviously there was no whiff of market power, be it in video games, which, as Your Honors noted, there's profound competition in still today, or any other element of the market. Apple had no market power when it set 30%. We would suggest it still does not have market power in app distribution because there's so much competition in it. But what has occurred since that first app or first iPhone is that the devices have become profoundly more sophisticated. Apple's, they have provided profoundly more opportunities for distribution and also for higher tech apps, if you will. So as our experts testify, the effective commission has actually gone down over these years. And so, Your Honor, there is the test, if you will, for whether or not there is competition would suggest that there is competition. The Epic has identified no anti-competitive conduct by Apple. They use the term, but they don't cite any facts. Their expert doesn't even use the term. And on the pro-competitive side of the scale, the evidence is overwhelming.
Right, I interrupted you. You can go back to what you were arguing.
Oh, thank you, Your Honor. And by the way, on that, Your Honor, I would suggest that when Epic suggests that it doesn't challenge the 30% commission, that's exactly what it challenges. Epic, and I realize we aren't to the tying claim yet, but it's not credible that Epic has a problem with IAP as a technical element of the App Store. What Epic does not like is that IAP and the App Store are taking 30% of the business model that Epic has chosen to implement. Your Honor, finally, in terms of what market this court should be looking at for purposes of today's motion, the only evidence in front of this court relates to Fortnite and relates to Epic. Therefore, when we are talking about what is the relevant market for this motion, The only evidence that's been offered this court relates to Epic and Fortnite. The court has no other basis from which to evaluate the competition in the marketplace. In fact, the only other product identified is a reference to Pokemon by Mr. Evans, or Dr. Evans, as he attempts to distinguish Fortnite